Law on obligations and contracts. The law. A person desiring to engage in a business in the tourism, travel, and hospitality industry will meet certain obligations. Therefore, there is a need to study the fundamental principles involving law on obligations and contracts. According to Article 1156, an obligation is a juridical necessity to give, to do, or not to do. Juridical necessity means a thing that are in need for something that may exist by the law. An obligation is a legal duty, however created, the violation of which may become the basis of an action of law. Every obligation has four definite elements, without which no obligation can exist. First is an active subject, also known as the obligee or the creditor. Next is the passive subject, also known as the debtor, who is bound to perform the prestation. Prestation means a duty to do or not to do something in fulfillment of an obligation or the performance of such duty. Third is an object or the prestation, which is an object or undertaking to give, to do, or not to do. Lastly, the juridical or legal tie, the vinculum which binds the contracting parties. The following are the obligations of the passive subject in: first is the obligations to give a determinate thing. Second is the obligations to do. The sources for liability for damages of a party in an obligation are as follows. First is the fraud. The fraud is an incidental fraud, which is fraud incident to the performance of an obligation. Second is the negligence. The negligence referred here in the case of contracts is culpa contractual, the lack of diligence and carelessness. The law. According to Article 1157, obligations arise from law, contracts, quasi-contracts, acts or omissions punishable by law, and quasi-delicts. There are only two sources of obligation, which is the law and the contracts. A contract is a meeting of the minds between two persons whereby one binds himself with respect to the other to give something or to render some service. Quasi-contract refers to a lawful, voluntary, and unilateral act based on the maxim that no one shall unjustly enrich himself at the expense of another. There are two common forms of quasi-contract. First is the solutio indebiti, which is the payment by mistake, and second is the negotiorium gestu, which takes place when a person without the consent of the owner assumes the management of an abandoned business. Quasi-delict, also known as culpa aquiliana, is any act or omission which causes damage to another, there being fault or negligence and there being no pre-existing relation between the parties.
Classification of obligations. Primary classification of obligation under the Civil Code: pure or conditional obligation, which is not subject to any condition and no specific date is mentioned for its fulfillment and is therefore immediately demandable. Obligation with a period: one whose consequences are subject in one way or another to the expiration of the said period of term. Joint obligation: there is no right to demand nor a duty on the part of each of the latter to render entire compliance of the entire obligation. Solidary obligation, which is creditor has the right to demand. Obligation with a penal clause, which operates as a previously stipulated indemnity. Next is the secondary classification of obligation under the Civil Code: the unilateral and bilateral obligations, real and personal obligations, civil and natural obligations, and legal, conventional, and penal obligations. Modes of extinguishing obligations. First is the by payment or performance, by the loss of the thing due, by the condonation or remission of the debt, by the confusion or merger of the right of the creditor and debtor, by compensation, and by novation. Contracts. Discussion of the law. Essential elements of a contract. First is the consent, object certain, cause of the obligation.
Characteristics of contracts. First, mutuality of contracts. Its validity and performance cannot be left to the will of only one of the parties. Autonomy of contracts. Parties are free to stipulate terms and provisions in a contract as long as these terms and provisions are not contrary to law, moral, good customs, public order, and public policy. Relativity of contracts are binding only upon the parties and their successors in interest. Exception, stipulation in favor of a third person, as in a beneficiary of an insurance policy. Consensuality of contracts are perfected by mere consent, and no form is prescribed by law for their validity. Exception, real contracts and contracts covered under the statute of frauds. Obligatory force of contracts. It constitutes the law as between the parties are compelled to perform under the threat of being sued in the courts of law. Classifications of contracts. First, according to their relation to other contracts. Preparatory, which have for their object the establishment of a condition in law which is necessary as a preliminary step towards the celebration of another subsequent contract. Examples, partnership or agency. Principle, which can subsist independently from other contracts and whose purpose can be fulfilled by themselves. Examples, sale, lease. Accessory, or those which can exist only as a consequence of or in relation with another prior contract. Examples, pledge or mortgage. According to their perfection. Consensual, or those which are perfected by the mere agreement of the parties. Examples, sale or lease. Real, or those which require not only the consent of the parties for their perfection but also the delivery of the object by one party to the other. Examples, comodatum, deposit, or pledge. According to their form. Common or informal, those which require no particular form, example, loan. Special or informal, which requires some particular form, examples, donation, chattel, mortgage. According to their purpose. Transfer of ownership, example, sale. Conveyance of use, example, comodatum. Rendition of service, example, agency or lease of services. According to their subject matter. Things, examples, sale, deposit, or pledge. Services, examples, agency, lease of services, and labor. According to the nature of the vinculum which they produce. Unilateral, or those which give rise to an obligation for only one of the parties. Examples, comodatum. Bilateral, which give rise to reciprocal obligations for both parties. Examples, sales or lease. According to their cause. Onerous, or those in which each of the parties aspires to procure for himself a benefit through the giving of an equivalent or compensation. Examples, insurance. Gratuitous, or those in which one of the parties proposes to give to the other a benefit without any equivalent or compensation. Example, comodatum. According to the risks involved. Commutative, or those which each of the parties requires equivalent of his prestation, and such equivalent is pecuniarily appreciable and already determined from the moment of the celebration of the contract. Example, lease. Aleatory, or those where each of the parties has to his account the acquisition of an equivalent of his prestation, but such equivalent, although pecuniarily appreciable, is not yet determined at the moment of the celebration of the contract, since it depends upon the happening of an uncertain event, thus charging the parties with the risk of loss or gain. Example, insurance. According to their names or norms regulating them. Nominate, or those which have their own individuality and are regulated by special provisions of law. Examples, sale, lease. Innominate, which lack individuality and are not regulated by special provisions of law. These are classified into four groups. Do ut des, or I give and you give. Do ut facias, or I give and you do. Faciut facias, I do and you do. And faciut des, I do and you give.